meeting will start. Good morning, everyone. Before we start, if everyone can turn on your microphone, make sure it's on if you want to talk. And please make sure your phone is off and volume down. So good morning, and I'm glad everybody was able to make it to our first 10 o'clock Monday meeting. So having said that, has everybody had an opportunity to look at the previous meeting's minutes? And do we have a motion?
I have a motion to accept the minutes of last meeting.
I second.
And do you want to make a roll call, or is it okay with the?
All in favor, say aye.
Aye.
Any opposed? But just for the record, because this is a quasi-judicial hearing today, I do want to do a formal roll call.
Okay.
Chairman Delange?
Here?
Vice Chair Horian?
Here.
Board Member Pollard?
Here.
Board Member Desai?
Here.
Board Member Lilly?
Here.
And our alternate member, Mr. Monaco.
Here.
Thank you, Sherry. And before we go on to the first agenda, we want to make sure that we follow the correct ruling. So our attorney, if you can go ahead and give us your spiel.
Of course. There's just a little bit of information that we have to go through procedurally before quasi-judicial hearings. So because this is a request for a zoning variance, it's quasi-judicial in nature. And that means that the public hearing needs to comply with certain procedural requirements under Florida law. Quasi-judicial proceedings are less formal than proceedings before a circuit court, but more formal than normal city council meetings, and so they must follow basic standards of notice and due process. So please note that only competent, substantial, fact-based testimony or evidence will be considered by the board in deciding quasi-judicial matters on today's agenda. Speculation or opinion, not based on competent facts, cannot be legally considered by the board in weighing the appropriateness of the application. So citizen testimony with fact-based support, such as surveys, engineering reports, personal observations, or knowledge, can be considered competent and substantial evidence. If you do intend to speak or offer testimony on the agenda items that are quasi-judicial, please keep all of this in mind. And when you approach the podium to speak, please state your name, complete physical and mailing address, whether you live in the city, and whether or not you have been sworn in. You should be sworn in if you are a member of the public who is coming to speak on the zoning variance. And all comments and presentations will be limited to 3 minutes, other than those on behalf of the applicant or the city. And only one presentation should be made per person. At this time, if any of the board members have any conflict of interest or ex parte communications with the applicant that they would like to disclose, now is the time to do that.
Thank you.
That's good enough. And at this point, any individual, including the applicant, experts, staff, or members of the public who are planning to speak or offer any testimony during the public hearing, you should rise and be sworn in by the city clerk.
Raise your right hand. You swear to tell the truth, the whole truth, nothing but the truth during today's quasi-judicial hearing.
Thank you. Gwen?
Thank you, Chairman Delange. Good morning, Vice Chair Horian, and board members. I'm Gwen Herstein, City Planner. This is a zoning variance request to allow 11 already built one-bedroom units in a 72-unit hotel to exist under a multifamily residential use with less than the code required 1,000 square feet minimum. 10 of the 11 units have 890 square feet or are 110 square feet below the minimum. One unit has 830 square feet or is 170 feet below the minimum. Property location is 1901 South Atlantic Avenue. The owner and applicant are both present this morning. Owner is 1901-1903 South Atlantic LP, and they're represented by the applicant, the Storch Law Firm, and there's a representative here for each. Future land use is high intensity use. Current land use is as a hotel, 72 unit hotel at the Max Daytona Beach Resort. This zoning variance request was initiated after a conversation was had with city staff about changing the building's use from hotel to multifamily residential. That took place in late 2025. While rezoning is not necessary due to the dual zoning district the property is located within, existing property elements below the minimum requirements of the desired multifamily use must be altered or must obtain an approved variance, which is the reason for today's hearing. This request addresses only one such requirement because that's the only one that needed to be altered. A representative, as I said, for the property is here, both from the Storch Law Firm, Joey Posey, and for the property owner, John Ott. And they'd be happy, I'm sure, to answer any additional questions you have about the change and the aspects that staff doesn't cover. This is the site location. You can see the Shores Community Center where we are this morning at the bottom with the green star. And the property in question is on the ocean. It is approximately 2.8 miles north of where we are right now and about a 5-minute drive. This is the zoning map and of the area. You can see the 1901 South Atlantic Avenue property is the northernmost property on the right, so on the east side. It also happens to be the northernmost property within the city of Daytona Beach Shores. The property immediately north of it is the Daytona Beach property. Here's an aerial, kind of a loud aerial of the area. You can see the map, Daytona Hotel surrounded by red. You can see the properties both in the Daytona area and then immediately south of the area. And here's a street view of the 1901 building as it currently appears. Red landscaping was just redone, so it looks a little different. This is one of the subjects, or rather 10 of the 11 subjects of today's variance proceeding. 10 of the units that are currently 890 square feet appear the way that you're seeing them on the screen. There is one, if anybody caught it while you were reviewing the file, there is one mistake on this plan page, and that is where it says 11 units total. That should read 10, oh, somebody caught it, maybe a couple of you caught it. It should read 10 units total, and I will be sent the copy of that page as soon as it's received. And it is our understanding that that is the current number of units in that column, only 10, not 11. This is the one unit, I'm sorry, I'm going to go back. That property, that column and that unit layout is on toward the southeast corner of the building, and then is in a column all the way up to 10. This unit, however, is on the northeast, in the northeast corner area of the building. It is a single unit that is situated and configured the way it is, and it has 830 square feet rather than 1,000 square foot minimum. Of the 7 criteria required to be reviewed for variance consideration, staff believes they have all been met in the manners outlined in the planning analysis, pages 28 and 29 of the agenda packet. Public notice requirements have been met and staff review has been completed. Staff analysis and exhibits have been submitted for the record. Staff is recommending approval of this variance request. Do you have any questions?
One question. Could you give us a background as to why the 1,000 square foot was initially there to begin with? Why isn't 800 square feet?
It was put in place back in, I believe, in 1991. We can ask if that is incorrect, the director to come forward, but back in 1991 it was placed in that manner, and he can give us a bit more if to answer your question.
I'd like to know why. What's that number?
I'll call him up, I think, after I'm finished.
Gwen, I have a question. In 2018, this was permitted as a residential unit.
As a
72
residential
units,
building.
high-rise residential. And then through the design process, it changed.
Through the building process, actually, the building process was already underway, and the owners decided that they would prefer to use it as a hotel, which meant one particular change that they wanted to make, and that was to include a restaurant on the first floor. And I don't want to get into it too much because they're here and they can answer the questions, but my understanding was that restaurant that they decided to add when they decided to use it as a hotel was what caused these units to go with a slightly smaller configuration.
So I was just trying to understand that it was permitted,
The site plan, when it was approved, the site plan was approved as residential multifamily.
so all of these units then met that criteria.
At that time,
At that time.
yes, that's my understanding, and they were altered during the building process, with plans, of course, a new set of plans was submitted.
So it was the property owner that decided to change this and move it from residential to a hotel and shrink those sizes.
Correct.
So the variance now is to relieve them from that, but that's something that they did themselves, self-inflicted.
In a manner of speaking, yes. They did not have control over market conditions that have changed, which is what's been represented to me as the reason for the change then and the reason for the change now. But other than that, yes.
Are variances for economic conditions or financial reasons?
I understand your question, and basically, there are unusual circumstances to the building, which is the construction method, and I do have the building official here to explain how it is different. But the building was constructed in a different manner using a transfer beam, and he's got an image here that he can go through with you, but that prevents them from moving walls within these units, and units in this area in particular, from moving them to bring them back to the 1,000 square feet.
But that construction was done by the property owner, it wasn't dictated by anybody else, they did that themselves.
An architect
transfer beam,
designed.
the whole thing, so that was all self-done.
An architect designed the
Exactly.
configuration of the building, and
Right.
yes, they decided to add my understanding is they decided to add the restaurant when they decided to make it a hotel.
It is currently permitted and used as a hotel today?
At this time, yes.
So is there a hardship?
That's something that the property owner and his attorney can answer for you if there's a hardship. It's been represented to staff that the market conditions have changed such that it's untenable to continue to operate it as a hotel.
Okay, I mean, because this is all self-imposed, I mean, by the owner, not.
The way that it was
property
designed,
managers.
yes.
So
Okay, sure.
so for clarification purposes,
Yes,
what we are approving or not approving is the fact that it's less than 1,000 square foot.
correct.
And that's what you want us to focus on. The approval is, we approve a condominium under 1,000 square foot.
Correct. Condominium, or, well, residential units, which are,
So my question is, you indicated earlier that this 1,000 foot limit was set in 1971?
1991, when the Land Development Code was first enacted.
Because to my surprise, I know for a fact that the Ocean Terraces across the street, there's a bunch of them with less than 1,000 square foot residency. Were they then grandfathered in, or is that just out of curiosity? Because I looked up and there's a lot of units that are under 1,000 square foot, specifically the Ocean Atrium.
Thank you, Mr. Chair, board members. For the record, my name is Stuart Cruz, Community Services Director with the City of Daytona Beach Shores. I have an AICP certification, which is an American Institute of Planning certification with the United States. I also have a master's degree in planning for regional and urban areas, and I also have over 22 years of urban planning experience here in Daytona Beach Shores as well. So to answer the question regarding the 1,000 square foot minimum for one bedroom units within the RMF1 zoning district, because the city is divided into different zoning districts, and every zoning district has different minimums and maximums that are allowed. That particular number was instituted when the city's land development code was adopted in 1991. And the reason why that number exists is because, as we know, residential living is different from hotel transient living. And so, whereas with a transient living experience, you're not expected to have, I'm sorry, I'm suffering from allergies right now. You're not expected to have certain type of residential amenities, such as a dining area and a residential feel towards the particular unit that you're staying in. Residential condominium units on Beachside at the time when the city's code was adopted expected, and there was a need, and there was actually, it was part of the lifestyle in which you not only have a bedroom, you not only have a kitchen, you not only have a restroom, but you'd also have a dining area and a den and other things that are basically compatible and expected with residential type living. And that's the reason why that number came up. If you were to go on the west side of South Atlantic Avenue in another residential zoning district, say the RMF2, for example, that unit size would be smaller because of the type of units that were contemplated by the city's comprehensive plan. In other words, the city wanted to have smaller units, perhaps a little bit more rentable, as opposed to on the east side where the units were expected to be more of a permanent residential type usage. So I hope that answers your question. But one thing I do want to clarify is that we do have the applicant here, and they can present their case to the board, and after that, city staff can answer any kind of follow-up questions with regards to the specific details of the code required tests for variances. That's okay and pleases the board.
Thank you, Stuart. Any,
Well, I'm still thinking about the old Holiday Inn. Yeah, the old Holiday Inn up there that's, individual units are like 500 and 600 square feet.
Can you remind me which one is the old Holiday Inn?
1909.
It is Oceanside Inn.
Oh, Oceanside Inn. Okay, so I apologize. So that is actually a hotel. That's not a residential form of ownership.
People live there full-time.
So that is a subject that we probably don't want to get into too much detail with today, but it is designed and approved as a hotel. The form of ownership is a condominium form of ownership, but is not intended, designed, or built, or approved for residential long-term living pursuant to the city's land development code and code of ordinances. But you're correct. There are some
I
very
remember when the LaCours owned it.
I'm sorry?
I remember when the LaCours, who had all the Holiday Inns around here, owned it. And it was a whole Hotel Inn, and it
Correct.
flipped to what it is now.
Correct. So again, that was approved, designed, and built for transient usage, basically as a hotel. And at that time, they had one owner, but eventually, the ownership form changed to condominium. In other words, the developer, the owner, sold it off to individual unit owners. But the use and the approved, and what we have in the city's records is that that is a hotel establishment. Whether people are living there or not, that's a different subject. So if it pleases the board, we'd like to ask the applicant to come up and make
I
their
have
case.
one more question. So did I hear you say correctly that the zoning for the Max Hotel is a different zoning that for the Ocean Terraces? Is this Ocean Terrace under the same classification zoning than what the Max?
So Ocean Terrace, is that on the east or west side of the road?
Right here, it's the Ocean Terrace right across on the east side of the road. There's Ocean Terrace 1 and Ocean Terrace.
Atrium.
Atrium.
Oh, okay.
Atrium. I'm sorry. Thank you.
I apologize.
Yeah.
I apologize. So the zoning district, technically 1901 South Atlantic Avenue has what's called a dual zoning district. Hotel, motel, and also multifamily residential. But when it was approved, it was designed and built as a hotel motel. But they also have the entitlement or the right to convert, if they meet the city's codes, and obviously building codes as well, to convert to a multifamily type of residential living. Ocean's Atrium now is only a singular RMF1 zoning district, so they couldn't do hotel motel if they wanted to live there, but the RMF components are the same. So the reason why those units might be smaller is because those were probably built before the city's code minimum unit square footage for one-bedroom units probably came into effect. And that's why, there's a lot of, actually, if you were to drive up and down A1A or go to any zoning district within the city of Daytona Beach Shores or any zoning district in anywhere in the state of Florida, United States, you're probably going to find a handful to maybe a few hundred properties that are non-conforming in regards to the existing land development code and comprehensive plan that exists today. It's a standard thing.
Understood. Any other questions or concerns? All right.
Thank you.
Sworn in.
He's the lawyer.
Well, he should be sworn in.
Good morning.
I don't mind, though. Good morning, and Joey Posey, 420 South Nova, attorney for the applicant. I do want to say that I also appreciate us starting at 10. I know it wasn't for me, but it was very nice of you guys. Just based on the conversation I'm hearing, and just it's a brief PowerPoint to touch on a few points that I think will be helpful. I think that what Stuart had mentioned about lifestyle changes is very important to this, given that, over time, you're just seeing spaces shrink in terms of usable space, as to how you utilize your condominium. We don't live in 3 to 4 bedroom homes as much anymore, and I'm sure there's still a desirability. The same is true of condos, and that less is many times best, and if you can amenitize the rest of the building to accomplish the same goal, that makes more sense from running the operations of the condo, but also just how the lifestyle of folks that utilize condos. So, as staff mentioned, the staff report went into a lot of detail that touched on a lot of the points. As she had mentioned, it was a 32-unit luxury residential condominium, or hotel use, which at this point is being transitioned into those units trying to trigger the condominium, and that's really what we're focusing on. It's that, is the nature of the duration of use is what's important here. That, of course, these folks would love to encourage those folks that want to make a home here. So that was really the goal. How do we get these folks into this very nice building? And to do that, we would have to go to a condominium form of ownership, which from the city's perspective, I imagine makes sense. And as a condo owner, you would expect them to take better care of their units, to treat them with the same respects you would as your home. And at the same time, I think this is the nuance for this project, is you don't sacrifice the amenities. It's the same amenities that the hotel was functioning under, which is a huge bonus for many of our older residential condos. That's something that I think that want to be encouraged. That when you're talking about how to accomplish this, the nature of the condo, the unit, the amenities that come with it, that's a very big plus in trying to make the highest and best use for the city, for the folks that come and go from the condo, and even the property owner's perspective too. Pointed these out. Something I do want to point out that's interesting is just how the definitions read in your code when it talks about interior space. The reason we're stuck at 830 and 890 is because it doesn't include the terrace. They don't want you have the terrace in part of that calculation. So if you're technically thinking from what the unit owner has control over and can use as part of the condo, well, that's their terrace. So we would meet the minimum unit requirement if we got to include that, but the code doesn't let us. So, and I'm sure there's a reason for that, and it was intentional, but from the perspective of whether these units, in terms of total space, meets the minimum requirement, it does. It just doesn't meet the minimum requirement in terms of interior living area. The other thing to keep in mind too, these are very nice condos. These are just some pictures I just wanted to point out of how they're designed. They're very upscale, they're very nice. They come with all the typical amenities you would expect when you buy a condo. These are not something that's trying to be take advantage of the fact that we're missing that 100 feet in terms of livable area. It has everything you could possibly need. And this is the terrace, as you can see, the access point in terms of the bedrooms. It's functionally a condo that meets the minimum requirement in terms of living area. It's just by implication of how the code reads in the definitions, you can't get there. And part of the reason we can't get there, as Gwen had pointed out, is the construction of the building. You just literally can't move the wall since it's you know, how the columns are placed. And that wasn't something that the applicant was thinking about several years ago when they designed this building. You know, again, they didn't intend and functionally try to make this building a hotel. That was the goal. And that was really until recently, and trying to encourage the use of these units, that was how they were operating. So at minimum, and again, we already went through the variance criteria, so you know, the minimum, as we had stated, in terms of hardship, again, the applicant did not go through this process intending for this outcome. You know, of course, you know, hindsight being 20/20, I can understand maybe some of the perspective, but you know, the goal here is to try to utilize the building in the best use possible in terms of how do we accomplish what I think its intent is, which is if you can go to those condo units, I would have expected, just from by implication, that maybe all control of the area makes sense, how you can incorporate the amenities in terms of the very large the gym area you guys have. There's a bunch of other things that are incorporated into the hotel, but you know, in terms of what the goal of what the zoning district was trying to achieve, it clearly falls into that. What the wisdom of 1991's planning staff, I'm sure it was well intentioned, but the realities of 40 years have changed a little bit of that dynamic. And, you know, that's the reason why we're here. So if there's any specific questions, we're happy to answer them or clarify any of the confusion, but we're happy that, you know, staff has worked with us and put a lot of time into this, and happy to answer any questions.
Question I have, Gwen said that they redesigned the building to add the restaurant in, and you had mentioned that this was always the intent of this building to be a high-end residential condominium.
Well, condominiumized hotel, I think that's the confusion. It's the hotel use that was intended. And then we've transitioned into, well, the long-term living is what the market's telling us that folks want. They want somewhere to be there long-term. The short-term is not as, it's just not dictating how we're best use of this property.
So to go along with that, when they were putting in the restaurant, they could have moved the walls, and they could have made those 890 square feet 1,000 and then 830 1,000 at that time before it was completed, and it would have gone along with exactly what you said, dual purpose. But it may have or may not have reduced the density, and maybe you would have lost a unit or two. I don't know, I'm not a planner or an architect, but I mean.
Well, and I guess I would concede if I had a crystal ball, I'd agree with you, but I think the argument's true of every piece of property. If everybody knew what the future would bring in terms of what the end use is going to be, then every building would be shaped that way. And you know, that's difficult, given that, you know, obviously these folks came forward with an intention to do the hotel type style use, and now what they're here asking before today is essentially, you know, how do we accomplish what would be a better outcome? You know, how do we take what we have in terms of its design, its quality, all the amenities that are associated, and how do we achieve what would otherwise be, by implication of anywhere else in the city and many zoning districts, the same outcome? A condo for long-term use versus a hotel.
And I understand nobody has a crystal ball and you can't predict the future. We'd all like to be able to do that. None of us would have to work again. None of us would have to work again. I get it. But at the same time, though, if this had been done back then, we wouldn't be here. And I guess it got to the fork in the road and you took it and went off to the hotel and reduced the square footage and went with that. And I understand that, you know, the variances are for hardships, but economic hardships are not one of them. at least my understanding.
And I agree with you,
So we can take it
but we're
as
not
it stands.
necessarily arguing just an economic hardship, that the building's designed the way it's designed. It's permittable to design the building the way it is. The difference we're asking is whether or not the utilization of that space for long-term use is something that we would get relief and hardship to try to accomplish to make better use of the property, and also accomplish what would otherwise be the same right many other zoning categories have. You know, again, and also I guess the unintended consequence of how the code reads, that if I get to include my terraces, we don't have this discussion. So, you know, again, weighing in the totality of it, that's the balancing we're talking about. Where, you know, I think if every variance is read with terms of strict letter, nobody would have variance, because, you know, it's a totality that we're talking about.
Thank you. Any other questions? I had a question for the staff.
Go ahead.
In reviewing your criteria for the approval, because it seemed like the staff recommended approval because it met every criteria, was additional parking considered in this criteria because it's switching from hotel to residential? Does that have an increase in traffic flow or parking?
It is actually was built and designed to meet the standards of the parking as would be required with a residential multifamily building. So they had an excess of parking.
Yeah. But across the street of that parking area, are they going to utilize that as parking, or is that going to?
They don't need to utilize that. They may end up utilizing that.
Okay. Because that is still their property.
It is.
All right. All right. Any other questions or concern?
I was just going to comment that the reason why you do not include terraces or balconies because the code says heated or air-conditioned areas.
I
And the
understand.
second thing is, those are called limited common areas in the state of Florida, not part of your unit.
And I agree, and I'm only saying that it's exclusive control of the unit owner. That is theirs.
Well, it's theirs to use on a limited common area. It's not exclusively theirs. It's like a designated parking space. You can use it, but it's part of the limited common area.
Well, and I
live in
understand your
condos.
distinction. I understand your distinction.
I just wanted to clarify.
Understood, and I'm just pointing it out to that. It's theirs to control in terms of use in that exclusive.
In a limited area.
In that limited area, of course, I agree with you.
Thank you.
And the balconies were not considered in the staff's argument, although it was tempting. You know, one of the balconies is extremely large, but it does not.
If you screen it in, it's a completely different story, yeah.
That's the interesting implication of this. Screen.
Stuart, you have a comment?
Board members, again, was there any final questions that the board had for staff? I just wanted to conclude real quickly with closing comment, if that was okay? Unless the
Well,
board had any specific questions for the.
Go ahead, before we call for public input in favor and oppose, if staff can finish and wrap up.
Sure. I just wanted to conclude, Gwen put a lot of time working with the applicant on this particular application. Staff is recommending approval, and as you can see in the staff report, it's our professional opinion that there is a special condition or circumstance unique to this property that exists, and that is typically the first test that has to be met in order for all the other tests to go through. And staff's opinion is that there is a special condition or circumstance that exists, and that's the reason why when you look at your staff report, you can see a chart that summarizes all the different criteria, and staff use all those criteria necessary for a variance to exist. And so we are recommending approval. And one thing that has nothing to do with this, but it's just a side comment, is that the national average for residential one-bedroom units in the United States is basically 700 to 800 square feet, whereas in the state of Florida, it's 800 to 1,000 square feet. None of these units are actually going below 800 square feet. So I just wanted to make that comment.
I have one question for you.
Yes, sir.
If they do not get approved for this variance, can they still use those 11 units as hotels?
So that is more a question for the building official, in the sense that dual usage concurrent at the same time is something that I'm not aware of that would be allowed under the Florida Building Code. Correct. So the building official just nodded his head negatively. So
You can't use a
It cannot. But the other, or the remaining, what would that be, 69 or so, would be able to be used for multifamily
So
residential.
it'd be just dead space. You couldn't use it for anything,
And
except
that's-
storage.
I'm not sure, that would be a question more for the applicant to determine how to use it if the variance was denied.
Well, how to use it, they just can't use it as a hotel.
Absolutely correct.
Thank you. Just wanted to know.
Thank you.
I just wanted to mention, I do want to point out that, you know, again, your professional staff has obviously indicated their position on this, and, you know, I do appreciate that reasonable minds can differ. I 100% understand that. But, you know, in terms of what we're talking about and whether this meets the variance criteria your staff has found it meets it, we've shown through our application that we meet it, and although we may have a difference of opinion, which I'm first to admit that that's why we're here, that's why we're discussing these things, that, you know, the basis of what we're relying on is these folks over here. And also, I do have, if there's specific questions of concerns, you know, I would love to keep that dialogue going and, you know, have those discussions rather than, you know, maybe shoot from the hip real quick and not have that opportunity. So, you know, when you're keeping in mind in your deliberations, please, I appreciate that. And, you know, and of course, I may get John to come talk to this because, you know, some of the history here too, he knows better than I.
Appreciate it. Thank you. We'll move on if there's no other questions. Call for public input in favor. Anybody in the public? Those opposed? None? All righty.
Mr. Chair, before you move on to your discussion, I actually do have another point of order for legal standards that will help you in moving into the motion and discussion portion of this conversation. So at the time of making a motion, if the motion is to deny, it's appropriate for the basis of that denial to be stated. It's not required, but it is appropriate. And under Florida law, the denial of a quasi-judicial matter cannot be based merely on a determination of the public sentiment regarding the project. And there's a few legal standards to keep in mind in assessing the application. One is that the landowner has the burden of proving that the proposal is consistent with the comprehensive plan and complies with the procedural requirements of the zoning ordinance. That is the standard. And at that point, the burden shifts to the governmental board to demonstrate maintaining the existing zoning classification with respect to the property accomplishes a legitimate public purpose, and the board has to show that a refusal to rezone the property is not arbitrary, discriminatory, or unreasonable. If the board carries its burden, the application should be denied. If it does not carry that burden, the application should be granted. And additionally, when a denial of the zoning application would be inconsistent with the comprehensive plan, the local government has the discretion to decide that maximum development density should not be allowed, provided the governmental body, again, approves some development consistent with the plan and the government's decision is supported by substantial competent evidence. So again, as was mentioned at the beginning, the decision does need to weigh the competent, substantial, factual evidence and not speculation or opinion. And so at this point, you can move forward with discussion and someone can make a motion to either approve or deny the application.
Thank you very much. Everybody understood that, right? No, thank you.
I can
No,
say
no, no,
less legalese if you'd like.
You gotta- I think summarizing that, if we're going to deny it, we have to have a specific reason for the denial. So I appreciate the clarification and specific aspect of it, so appreciate it.
One quick thing.
Sure.
I apologize. I just wanted to say that if, again, as you're deliberating, if this feels like there's other things that we need to take into account and to talk through, you know, the difference between 30 days versus telling this guy no is a very different outcome. So as you're talking, you know, I'd appreciate just that dialogue as it's coming through your deliberations.
This is a
Thank you.
Canadian company, right?
I'm sorry?
Canadian owners?
Yeah, but he's probably the most local of local Canadians.
Well, I mean, Toronto, Canada's a home base, isn't it?
There are principal,
Yeah, you would have to come up and.
did I say my name? John Ott, 11531 Willowwood Gardens Drive in Windermere, Florida. I live in Orlando. And I'm a U.S. asset manager representative. We have principals that are from Canada. The company itself is a Florida development company. Entity is a Florida entity. But Henry Walfond, our CEO, is a Canadian.
Thank you. Thank you. All righty. Any other discussion? Questions? All right, do we have a motion?
Mr. Chair, I apologize.
Oh, I'm sorry.
Can I speak? I mean, can I speak during public comment, or I didn't know when I should follow? I had a couple things I wanted to say.
Well,
Should I do later? Whatever you.
that was, I called for in favor, that's what I meant, but go ahead.
I'm sorry. I just wanted to say a couple things, and that is we do.
State your name.
Again?
Yeah.
John Ott, 11531 Willow Gardens Drive, Windermere, Florida.
Thank you.
Outside of Orlando. And I'm Vice President of Development for Bayshore Capital, one of the principal owners of this property. And I just wanted to say a couple things that, on the property specifically, but we own 5 pieces of land up and down the ocean. You're probably familiar with some of our less than successful endeavors. We were the developer of the Hard Rock Hotel because we believe in Daytona Beach and the Daytona Beach shores and trying to improve this. Henry always has. But we introduced the boss to the Hard Rock brand, convinced him, look, economically we can't build this. It got to be $170 million, bigger than we could bite off. But we believed in the brand and the market, so we introduced the boss to it, and the Westin converted over to a Hard Rock, and I think that has been successful. So we believed the same thing when we constructed Max, the Max Beach Resort, because we believe in this market. And just to clarify a couple things, it is true, we had our site plan approved as a residential project. During construction, we came to the conclusion that a hotel was a better economical model. It was the professionalization of Airbnb and short-term rental. There's a lot of short-term rentals in Daytona Beach. So the construction permit was as a hotel, the CO was as a hotel, and that change happened subsequent to the original site plan, which Gwen is correct, was for a residential condominium. So when we constructed this thing as a hotel, I was not aware of the 1,000 square foot requirement. So we built these units as what we thought was the best competitor in the marketplace for condominium type units, but you rent it as a hotel. And honestly, we are the highest rated hotel, the highest in satisfaction, and I think we're at the top of the market, and it proved to be true. But I was not aware, and we hadn't looked at that 1,000 square foot, which may be arbitrary because we were building this hotel. The market has improved, the hotel business is tough. We look like the shining star in the town, but I'm telling you, this is a rate competitive market. The hotel business is tough. The market has improved. We would like to convert the building using the rules of the Florida statutes to a condominium and sell them, which will potentially triple the ad valorem taxes. I know economics is not an issue, but for Daytona Beach shores. So really, that's the reason for the variances. The restaurant is the reason that smaller unit is 830 square feet because we took one of those bays and turned it into offices and restrooms for the restaurant. The others were just constructed the way they were constructed at 890 because I was totally unaware of this 1,000 square foot requirement when we built it as a hotel. So we would like this variance to allow us to convert the hotel to its approved use. And without this variance, I don't know if we'll be able to do it because, as you said, I'll have 10 units that I cannot sell. So that's the reason for the variance. Ignorance on my part of the 1,000 square feet requirement. But I just want to let you know, we believe in this market. We may not be done building in it, and hopefully, you'll see your way. Any questions before I step down?
No, I appreciate your comments and your presentation. Now, having said that, is there any public input opposing that presentation? There isn't? All right. So now we can go ahead with the motion. Is there a motion?
I move to approve the zoning variance ZV-A25-0013 as presented.
Second. Thank you. Gary, if you want to take roll call?
Mr. Horgan?
Yes.
Mr. Desai?
Yes.
Mr. Delange?
Yes.
Mr. Lilly?
Yes.
Mr. Palmer?
Yes.
All right. Thank you. All righty. So having said that, finish with the quasi hearing. So is there action items. Are we going to do with the 2025 currency management report? Stuart?
Thank you, Mr. Chair, Vice Chair, board members. For the record again, Stuart Cruz, City Community Service Director, City of Daytona Beach Shores. What I will be
Can you
presenting-
put it a little bit closer? Because I'm having trouble. There we go. Is it on? There it is.
Yep, it looks like it's on. Thank you. Again, Stuart Cruz, Community Service Director with the City of Daytona Beach Shores. What I'll be presenting at this moment, board members, is a concurrency management report for public facilities for the year 2025, basically last year. So as you may have seen in your staff report, board members, there is a concurrency requirement report that's required under the city's Land Development Code, Section 3-7. And essentially, every December, city staff or the concurrency manager is required to present the concurrency management report to the city commission. But in addition to that, the code also requires that this particular report is presented to the planning and zoning board and the city manager. And essentially what this report does is that it identifies any degree of public facility deficiency and the impacts on future development orders that are associated with those deficiencies. The public facilities that are required to be analyzed by the concurrency manager in this report include roads, or basically traffic circulation, sanitary sewer, solid waste, stormwater, potable water, recreation open space, and public schools as well. And so what is concurrency? So there is a definition in the city's land development code regarding what this actually means, but essentially what it means is, a simplified term, is adequate public facilities at the time a development comes online. So the code says it's a condition where specified facilities and services have or will have necessary capacity to meet the adopted level of service standard at the time of impact of the development in question. So essentially what that means is whenever something is being built, that the impacts that are associated with those with the development can be accommodated for by the public facilities that are being impacted concerning the level of service standard that is established for those public facilities. So what staff did was it analyzed all 7 of those public facilities as required by the code, and this particular chart that you see up there, the table that you see up there, covers the first 5 public facilities: potable water, roads, sanitary sewer, solid waste, class 1, which is basically your traditional household garbage or trash, and also stormwater drainage. And what you'll see on the right-hand column is that all those particular facilities have adequate capacity. What that means is that the capacity for the development, for any future development that exists, shows that there's a surplus to meet the impacts that might be associated with those particular development in such a way that the capacity is either at or above the level of service standards. And so when you look at water, for example, you'll see that both Daytona Beach and Port Orange, which provides potable water to the city of Daytona Beach Shores, have a surplus, and you can see it's in the millions of gallons per day in terms of treatment facilities. Roads, you'll see roads and stormwater drainage, those varies, but they all actually meet the adequate capacity test that's required in the concurrency management system. And something that I did fail to mention, but you may have seen in your staff report, is that every time a new site development plan comes into the city planner and the concurrency manager looks at those particular impacts that are generated for the site development plan and ensures that these tests are met. And so it's not something that that happens outside of the site plan development review process or something that's arbitrary. It's actually a part of the checklist, and it's actually something that's reviewed. In the case of public school facilities, staff along with the Volusia County School District analyze the development impacts associated with the level of service standards and ensure that those impacts meet or adequately covered by those particular facilities. And so within the public school system for Daytona Beach Shores, we have R.J. Longstreet, which is an elementary school. You have Silver Sands Middle School, Atlantic High School, and Spruce Creek High School. And the first one, the elementary school, you'll see that adequate capacity exists. There's actually a surplus of what's called permanent student stations. But for the other three, the middle school and the two high school, you'll see yes in the right-hand column with asterisks, but if you look to the left, you'll see that there are actual student generation as student permanent station deficiencies listed, hence the red and the negative sign. But if you look at the note, and if you actually look at the concurrency management report that I provided to you, you'll note that the Volusia School District has actually installed temporary student stations, some people call them portables and other things, and also have scheduled future classroom additions, and also made programmatic changes to accommodate these deficiencies. So while on paper it looks like it's in the red, it's actually in the green because those students are actually being accommodated for as we speak. And so again, whenever a new development comes into play, we not only look at the concurrency manager not only looks at the development impacts and the student generation rate for that particular, the student generation for that particular development, but the school district actually does that as well. So they're able to look into the details a little bit more than a student, that the schools, and the city staff can, and they actually provide a certification letter to show that adequate capacity exists or that reservation is made on the condition that future mitigation is made.
I have a quick question.
Yes, sir.
So that's pretty standard as far as numbers when it comes to the schools, but when it comes to sewer and water, in your previous, that is taken into account. Does that change on a yearly basis, or do the standards from the water management stay pretty consistent?
So it's not the water management district that makes those numbers. They approve what's called the level of service standards for every jurisdiction and every service provider. And so, for example, with water, we're required to provide a 10-year water supply plan, not only as a local government, which doesn't provide water, we still have to do that, but Port Orange and the city of Daytona Beach, they actually have to provide a permitting, they have to provide what you call a consent use permit that's renewed every few years to the water management district to ensure that adequate treatment and supply of water is available within a certain period of time. And so what happens is, as new development comes online, that number does change, and that's the reason why we always contact the city of Port Orange and the city of Daytona Beach Shores to ensure that the treatment facility, and not only that, but also the reservation capacity that is associated with every single, again, water, sewer, whatever have you, is consistent and not consistent, but can actually accommodate, and there's actually room again in the system to accommodate the impacts of that particular new development. And so every single city in the state of Florida goes through this process.
I just needed that clarification. Thank
Hopefully I
you.
didn't confuse you.
No. Appreciate it.
There's no effect on annexations because it'll be a wash, right?
So generally for annexation, if the property is developed and the change is the rezoning and future land use map amendment is from like to like, meaning single family to single family, or for 10 units to 10 units, then generally it is a wash indeed, correct. But if the property is indeed vacant and it will be developed in the future for, say, a multifamily residential condominium of, say, 1,000 units or whatever have you, then it's not a wash. We actually have to go through the analysis process to ensure and coordinate with Port Orange, Daytona Beach, whatever it is, whichever jurisdiction or service area it falls under, to ensure that adequate capacity will exist at the time whenever that property is rezoned or the future land use map amendment is made. But if they're just annexing in and they haven't elected to do anything further than what the current entitlement typically is, which is single family to single family, then there's no room for hesitation there.
Thank you.
Oh, oops, where am I? Okay, so the final public facility that was analyzed in the concurrency management report is recreation and open space, and you will see that the first 7, I believe, let's see, what's that? 2, 4, 6. The first 6 categories within that public facility or sub-facility categories within the public facility for recreation and open space, you'll see that we have adequate capacity for that if you look at the table to the left. However, the final 6 subcategories within the recreation and open space public facility category show that, yes, there is adequate capacity, but again, there is an asterisk, and if you look to the left, you'll see that there is a difference. And so, staff's conclusion is that due to the city population demographics and land availability and land prices associated with land availability, compared to the level of service standards, there's currently no need for additional amenities. And the level of service standards for these amenities may need to be reevaluated. So again, everybody knows what the Shores is. You know, our demographics is different from many others in Volusia County and throughout the state of Florida. The median age here in the here in Daytona Beach Shores, you know, you're talking, 60 years old more or less. And when you look at the actual sector within the younger age group that would require, say, children play areas, for example, is very, very small. It's actually less than not only the national average, but also the state average. And so the reality is, do we really need 5 children play areas in Daytona Beach Shores, right? We have currently 3, but according to our comp plan, we need 5 based on our population. And the answer is more likely no. And so for that particular capacity, we as staff concluded, and we have presented the City Commission already, that the adequate capacity does exist for the number of children age individuals that we have in Daytona Beach Shores. And then similarly, when you look at football, soccer field, baseball fields, do we really need that in Daytona Beach Shores? You know, again, the age group that utilizes these spaces in general, we don't really have that number here in Daytona Beach Shores to require an actual, soccer field or softball field. In fact, some of you who have been here for a while, like I know Mr. Lilly, for example, we used to have a softball field. You remember that, right?
What?
We used to have a softball field, but the reality is that the people who were actually utilizing the softball field were not from Daytona Beach Shores, right? They were from Port Orange. They were literally driving over the bridge to come utilize that space. So again, is this something that we actually need in Daytona Beach Shores? And the answer is more likely no. And so that is part of the analysis that staff did to conclude that all these different things, while they say no on paper, the reality is that we really don't need it. So staff is planning to reevaluate these level of service standards consistent with the Parks Master Plan that was recently done last year to ensure that we update these standards and provide a recommendation to the Planning and Zoning Board and to the City Commission to basically change them. Because the reality is that unless our demographic actually changes, these things are not needed. So when the city's comprehensive plan and the city's land development code were adopted back in the day, what most local governments do is they use national averages as their threshold or as their level of service standards. And unfortunately, the national average is not what is reflected here in Daytona Beach Shores. And so with that said, staff believes and concludes that adequate public facilities capacity does exist in Daytona Beach Shores and that there's no need to recommend a schedule of capital improvements for public facilities. And so generally, the reason why we do this is that if we identify a deficiency in, say, the road system or a deficiency in water treatment or whatever have you, the city would recommend, the staff would recommend to the City Commission changes to obviously accommodate those potential impacts in the future or for that particular development or whatever have you. And so there's no need, because from staff's perspective, there's no deficiency that actually is applicable to the city. And so there's no need to recommend a schedule of capital improvements and change our budget to build a softball field or a soccer field or whatever have you. And there's no need to recommend a moratorium for future development either. And finally, as I mentioned earlier, some level of service standards require reevaluation for relevancy here to Daytona Beach Shores, and staff will be providing something in the future to basically reflect that. And so the recommendation from staff is no action, but if you have any questions, I'll be happy to take those.
I have a question recommendation.
Sure.
Because I didn't see pickleball in there. And so every sport except pickleball in there.
So again, those standards have to be re-evaluated. So what that means is that some things may be taken out, some things may be increased, some things may be decreased in terms of standards, and some things may be added as new amenities in which we would have to apply a certain standard, since we are a growing pickleball community, not only in Daytona Beach Shores, but in the state of Florida. I was actually talking to one of my folks in Public Works the other day and a contractor, because we're having some pickleball court issues, and the contractor that we spoke to was saying that in South Florida, they're building over 150 new pickleball courts in this one city that's a little bit bigger than us. 150. Yeah. That's a huge number, at least for me. Yeah. So yes, it is growing, and indeed that will be part of our reevaluation of the level of service standards and public facilities going forward.
Okay, thank you. Any other questions? Or
I remember before this regime hit town, that the area where the ball field was, when the land was donated to the city, the codicil was it kept to be a ball field. That's how far back I go.
Yeah, me and you, we
One
go
of our
back
mayors
the
said,
same time.
Huh?
I said, me and you, we almost go back to the same time period.
Yeah, well, I don't know what happened to that, but.
Any more questions for staff?
Does that conclude your presentation?
That's it.
I have a question for you that somebody asked me and I didn't know the answer, and I have no clue what's going on. I remember almost a year ago that we were going to do a ramp at where the stairs are at the park over here. What's the name of that park? And we were supposed to start the ramp, and it's never, you haven't even started the ramp or any construction whatsoever. Can you give us an update on that?
So are you referring to the passive park that's just north of St. Kitts?
Yes.
So we are still going through the permitting process with the state of Florida. It's been a very arduous journey, and we believe that the state of Florida will not be issuing that permit. You know, we have a conference call request set up and with the state of Florida, and it's not looking good, unfortunately. And so we just can't go out there and take down the stairs and build an ADA ramp without their authorization. And so it's not looking good right now. Yeah. And one thing, I'm glad you asked that question, because for those of you who looked in the staff report, you may have seen an updated development condition list. Because again, every time a new development comes into Daytona Beach Shores, we have to analyze it for concurrency and public adequacy, public facility adequacy. So you may have seen, if you haven't seen it, just take a look and you'll see all the projects that have been approved that still have existing development orders, and you'll also see an expiration date for all of those. Some of them are only at the development agreement level, some of them are at the site plan level. The one thing I did want to note, thanks to your question, is that the Lux condo, which is scheduled to be just south of the St. Croix condo, across from the plaza, the formerly Red Lobster Plaza, which the new Sonapa is going to be going into, more or less. That project was approved through a site plan, but they recently submitted payment for building plan review. And so typically when you submit a $60,000 to $70,000 check to the city for building permit review, it's usually a good sign that things are moving forward. So I'm happy to say that things are looking up. We also have the Aston Martin Valor project as well at the 3411 South Atlantic Avenue property. That is complete in site plan review, and it's my understanding that right after that, they're going to be submitting their building permit application for review as well, and they're hoping that sometime early next year that they might be able to break ground. So, and now we have just on the agenda today, we also had the Max Daytona as well, which wants to convert from a hotel to a multifamily residential condo. You know, things are looking really, really good for the city of Daytona Beach Shores, and so I appreciate everything that the board had to do in order to get those approvals and make things move forward here in Daytona Beach Shores.
What again is going across the street from the Red Lobster?
So it's not exactly across from the Red Lobster, but just south of St. Croix condo. That vacant piece of property, it's the Lux condo. And I believe it's a 6 or 7 story.
It's 30 units.
It's a 7-story, 30-unit residential condominium. So the board had already seen that. The board approved it, I want to say maybe 3 years ago or so, 2 to 3 years ago, and now they've actually paid their permit fee to have plan review done. And so that is a positive sign.
Is it a common practice that these people take so long to do this after they're approved?
So,
I mean,
it is not,
like
when things are
2029.
good, typically it's not common practice, but you might remember we had not only COVID, but we also had the hurricanes, and under Florida law, so typically with the city of Daytona Beach Shores and most local governments, there's a certain time frame for the development to proceed without, I mean, before having the development order expire. Well, here in the state of Florida, under Florida law, whenever there is a disaster declaration made, they get extensions. It's a little of a funky formula that's utilized, but if you look at the development update list that I provided in your concurrence and management report, you'll see that I think the nearest, or the soonest, any one of those development orders would expire, I believe, is 2029. And so if there's another storm later this year, they'll get another time added to it, and so those expiration periods will move forward into the future as well. And again, you know, the government understands that during a time of crisis, you know, prices go up, there's limited labor, there's a whole bunch of markets change, there's a whole bunch of complications that go into that formula for a developer to actually build. And so the government made that particular provision in state law to accommodate and to be cognizant of those conditions that developers have to deal with.
Stuart, you mentioned, Rick had the question about the ramp, what to think kids. Doesn't look like it's gonna happen, so the ramp that was by Tuscany Shores, which had an easement, wasn't that easement abandoned in favor of so is that, I don't know where that ramp now, is that in jeopardy, or?
So staff will be bringing something forward to the city commission, more than likely at the next city commission meeting, to get direction from the city commission as to how to proceed. Because yes, there are some limiting factors that are involved in both properties, and obviously the biggest one is the conclusion and the determination that the Florida Department of Environmental Protection will make regarding the property north of St. Kitts.
Okay, but has the easement by the city been abandoned in Tuscany Shores now?
So I apologize, I didn't answer your question. So it has not been abandoned because the easement was, the ordinance that was adopted to abandon the easement was based on the condition, a contingency, that a permit be issued by the DEP. So until we get a final decision from the DEP, that ordinance will not become effective.
Thank you.
Thank you, Stuart. Thank you for the time and the update. We appreciate that.
No problem. And if you ever have any questions about anything on that list, please feel free to call Gwen Herstein, our city planner, and she'll be able to give you the most current information.
Call or text, or send an email.
Whichever works for you. Thank you, board members.
Thank you, appreciate it. All righty. So, Sherry, are we going to do the training?
Yes, sir. But we're going to go ahead and adjourn the meeting because the training does not need to be part of the meeting.
Oh, okay.
So 11.